Good afternoon. Welcome back to the second part of the webinar dedicated to the Q&A session. We will do our best to answer all questions received. However, those of which will not be answered due to time constraint will be collected and included in an updated FAQ document, which will be available on the dedicated CSP page on our website. Okay, so now let's go to the questions straight away. The first question, if a person is a foreign national resident in Malta and provides directorship services to entities to which he has been providing consultancy services for a while, would he qualify as a CSP even though he has no separate office or branch in Malta and attends meetings online or travels for meetings? Over to you, Petra.
Thank you, Romina. So yes, so the answer to this question is always that you need to go back to the key first premise of whether you require an authorization or not. And in fact, the law provides that any person operating in or from Malta and offering CSP services by way of business would require authorization. So in the context of this particular query, we understand that this individual would in fact be operating from Malta. So the authorization requirement does in fact apply. Thank you.
I am a director of 6 companies, 3 of which belong to the same group. Could you please confirm that I do not need to apply for a license because of the small number of directorships that I hold? Alison, could you answer, please?
So this is a particular question. With the introduction of Act L of 2020, the de minimis rule has been abolished. So now everyone who is providing the services by way of business needs an application need to apply with the authority. In this case, this director is saying that he has 6 appointments, 3 of which are of the same group. The group companies count as 1. So in total, there will be 4 appointments, and that makes it will be necessary to apply for an authorization in terms of the new regime.
Next question, Alison. Our client provides directorship services to licensed fund in Cayman Islands. Would this be considered exempt? Is Cayman Islands considered as a recognized jurisdiction? If not, would the fact that the licensed fund is managed by a licensed UK entity warrant the exemption?
Thank you, Romina. So in this case, basically the exemptions regulation says that you need to operate in a recognized jurisdiction. The Cayman Island, basically, we need to do a specific assessment about these different jurisdictions. So what we're proposing is that whoever has such appointments to reach out to the authority with the specifics, and then we will come back with a determination. There is also the fact that there is a UK company involved, but for the assessment as to whether the directorship counts for an exemption, in this case, the UK will not be a determining factor because the actual directorship is in the Cayman Island. As I said, this will be on a case-by-case basis, and we encourage you to reach out to us on our dedicated email address, and we will guide you accordingly as to whether this will count or not. Thank you.
The next 2 questions are for you, Petra. How many registered office addresses can be held by an office without having to make application for a license?
Thank you, Romina. So again, here the question is whether the service is being provided by way of business. So if this service is being provided by way of business, then authorization is required. Now, as per our guidance note, which we will find on our website, holding simply one or two registered office roles, basically offering one or two such services, would not be deemed to be by way of business. But obviously, this would not be the only test, because obviously if the person is, on the other hand, holding himself out as offering this service, that would still be deemed to being done by way of business, and therefore authorization would be required.
I would like to ask whether an unnatural person whose only service is sitting on boards of licensed entities by the MFSA needs to get authorization or is exempt by the new regulations in place.
So if a person is only holding directorships on licensed entities, in that case, the exemption applies and the person does not require authorization. However, on the other hand, if the same individual is holding both directorships on licensed entities and directorships on non-licensed entities, in that case, authorization would be required. Obviously, then it would what would make a difference is also how many positions one is holding, because the positions on the non-licensed companies would not count as directorships. However, authorization would still be required, but possibly there may be a variation in the applicable class.
The next two questions are for you, Alison. Is there a template for the wording of the guarantee, as the bank has asked for such and are unaware of it?
Okay, so we have no specific wording with respect to the bank guarantee. I was going to tell you to liaise with your bankers, but you are indicating clearly that the bankers are not aware of it. However, I have to say that we have, under the old regime, CSPs who have bank guarantees. What we take note that the banks might not be aware of the exact wording, and we will look into it and issue any further guidance if deemed necessary. One thing that I wanted to point out here is that the bank guarantee is an optional, it's an alternative to those CSPs who are individuals who do not have cash in a bank account or any other way of holding their capital requirements. For example, in one of our frequently asked questions, we actually said that you can have, let's say, government bonds. So because we have a lot of queries about this, so the bank guarantee is not a must. It's an alternative, so you might want to consider any other options in this regard.
I do not provide CSP services by way of business, but I do get asked. I do not have directorships, registered address, and do not incorporate new companies. In all circumstances, I normally decline. However, via some other business services I provide, there may be a case for an incorporation. This may happen once a year. Does one have to enter the CSP regime? I feel that by registering, onerous obligations are being imposed.
So, first of all, if at the beginning of the year, the intention is not to provide such services, but there is the possibility that you might be required to incorporate a company. This is what we refer to as the incidental to the main services of the individual or company providing services. What I wanted to specify with respect to incidental is that it is limited to incorporations, because obviously if you want to provide directorships or company secretary, that is an ongoing relationship. And at that stage, if you are approached to do such services, you will require authorization. With respect to the onerous obligation, I just wanted to do a side note here, saying that the obligations might seem onerous to some, but however, we have to bear in mind all that the rule book is applicable to everyone. And it is principle based, and the idea is that each and every applicant or current CSP will have a look at the rule book in its entirety, all the principles, and then adopt a proportionality aspect based on their business model. So that is one thing that we keep saying out there, and it is very important. That is how the proportionality aspect will be implemented. Basically, we do not know every single person's business model, so we have gone out with the principles, and then it's up to you to do your homework, look at the principles, and then come out with whatever is adequate at your end. Okay.
The next question pertains to the independent risk management function for Class C. Can you confirm that it can be outsourced to a third-party service provider, being fit and proper and subject to MFSA's approval, of course? It was mentioned external and independent. Could you please clarify, Petra?
Yes, so the risk management function indeed, in fact, can be outsourced to a third party, and as correctly pointed out by the inquirer, in fact, indeed, the risk management function, the person nominated for this post requires MFSA approval. So a PQ would need to be submitted and an assessment made to approve this proposed individual.
Currently, CSP services are carried out by my company. Shareholding is majority shares held by myself, a warranted accountant, and minority by my wife. She is not a graduate, but oversees administration and running of the office. The accountancy board accepted this setup. Will the MFSA have an issue to accept my wife as shareholder of a CSP company? If not accepted, what should be the ideal solution? Removing my wife entirely from the company, but then I would need an additional director on board. Please clarify.
Okay, so with respect to the roles of shareholders and directorships, the authority will look differently with respect to competence and knowledge. So what I wanted to say is that for shareholders, obviously, there might not be the requirement that they have full knowledge if this person is just a shareholder. So what we recommend at this stage is that the PQ is submitted if you deem that this is the appropriate way to continue doing the business in your wife's name in this case. And then when the authority will make the assessment, we will guide you as to whether it's acceptable or no. On your second question, you mentioned that we're not quite sure basically whether the wife is also a director. But what I wanted to emphasize is that with respect to directors, obviously the competence assessment is different and you need to have the knowledge and the experience. So this is something that you can approach us. Feel free to send us your query and send us any information, but whether you need a new director, remove your wife, include your wife, that is a business decision. We will guide you, as I said, and please feel free to send us your specific circumstances on our queries email.
Alison, the next question is very detailed. You have it in front of you. The question here is asking about a clarification on the use of the word only within the Exemptions Regulation 2021, Article 3C and D. If you could guide us through it, thank you.
Okay, so As Romina indicated, it's a very long question. It's about the exemptions regulation, and it is about the word only being used in Article 3C and D. What we wanted to say about the exemptions regulation basically is that it only applies to directorships and company services of licensed entities or listed entities. When we say licensed, it is important to keep in mind that licensed by the MFSA, it could be a license, registration, or authorization, but basically we have conducted the fitness and properness of these people. They are under our radar. They are obliged to keep their fitness and propriety. So those are exempt. What we wanted to add is that if the same individual is carrying out is providing other services such as directorship and company secretary, but in other entities, we have to go back to the by way of business test. If there is just, let's say, as an example, one holding, then in that case, it will not be deemed to be by way of business. The same if the company where the individual is acting as a director, basically it's his own company or a family company, that will not qualify as by way of business. However, if they are providing the services by way of business, authorization is required. What we wanted to clarify as well is that, let's say you have 5 companies of this kind where they are not listed or they are not regulated by the authority. In that case, when it comes to counting the involvements for a Class B under threshold, the listed or licensed entities, those will not count. The same question also asked about employment. If we have an employee who is providing directorship services by way of his employment, that person is not providing that services by way of business. But the question was whether authorization is required if this same employee has other appointments. In that case, authorization is required, basically, because that will not be an employment relationship. I hope that it has answered all the queries.
Would a person who is a director on companies, which forms part of the same group of companies, thereby resulting in one involvement only, still be required to apply for authorization?
Okay, so for this question, yes, we confirm that basically if a person is acting as a director on companies which form part of the same group, those count as one role, one position basically. So in that case, as per our guidance note, only one position is not deemed to be a service which is being provided by way of business, and therefore authorization is not required. However, here what I would like to highlight is that it's very important, if there is going to be any kind of change in circumstance or sort of any variation to this understanding, that you contact us immediately and we will advise on the way forward. We always promote a lot of transparency. We would rather you reached out to us and we guide you accordingly, rather than being in doubt and then possibly there would be a change in circumstances, which might in fact then give rise to an authorization requirement and you would not have sought the necessary authorization. So you are encouraged to reach out to us in case of any doubt and in case of any changes in circumstances.
Does the LH portal allow the PQ to be submitted despite the entry assessment being left blank?
Okay, so I understand that this question was mostly asked in the context of an individual who is applying for an authorization for a Class B under threshold and who is therefore submitting his PQ. The entity assessment in the PQ, for those who might not be familiar with it, is sort of a section in the personal questionnaire which provides for the entity proposing an individual to hold a position in that company, and they need to provide an assessment of why they deem the person to be suitable for the role. So if they're proposing John Doe as a compliance officer, why they deem John Doe to be adequate for the role they are proposing. Now, in the case of an individual, of course, in the case of Class B under threshold, this applies only to individuals, so we wouldn't be expecting an entity assessment to be made on that individual. And in that case, yes, we confirm that that section, in fact, can be left blank, and the portal will allow for the submission with that section being left blank. It does not, it would allow it also in the case of companies, but we would then come back to you, and obviously in that case, we would not accept it, even if the portal accepts it. Thank you.
Should the derogation from appointing a risk officer apply, would the person overseeing that function have to submit a PQ for that person? Alison.
Okay. Okay. In this context, I wanted to give a bit of background on the risk derogation requirement. For Class C, there is a requirement to have a risk officer. And we understand that for Class C, there are different business models. We have the small outfit, the individuals, we have the larger CSPs. So we introduced a derogation. The derogation does not require, if you are given a derogation as an entity or as an individual, basically what we're saying is that you need to appoint someone to be responsible for the risk function. That individual who will be responsible for the risk function does not require the submission of the PQ. But what I wanted to add is that the derogation is not something automatically. So if you're an individual, it's not automatically that you have a derogation. It is based on an assessment of the business model of the individual and on the information provided in the application form, and you have to specifically request that a derogation will be requested from the authority. I wanted to add that this derogation will be something that we will be looking at in phase 2 of the application process.
Can the authority kindly clarify what financial information is required from a Class B under threshold on an annual basis, and what exactly needs to be audited?
Okay, so for individuals, which in fact has been the case even for the current existing individuals who are licensed as CSPs, the financial information which needs to be submitted is in the form of the statement of solvency and compliance, which is in fact included as an annex to the rule book. And this in fact includes a statement stating that basically the individual's total and personal business assets exceed the person's liabilities, and that the person is able to meet the liabilities as they fall due. We intend, however, to issue some further additional guidance on this, on exactly the financial information which would be required to be audited. So we will be issuing further guidance on this, but as a starting point, definitely there is the statement of solvency and compliance, which is included as an annex to the rule book.
Could you please confirm that CSPs already registered will automatically be authorized and there is no need to apply again?
So yes, we can confirm that in fact CSPs who are already licensed, who are already registered in terms of the CSP Act prior to the amendments, the amended Act in fact provides that these will be automatically become authorized, and there is no need to resubmit the application. However, of course, they need to be classified into the new classes now. And in fact, what we're doing is that we are reaching out to all the CSPs and we are informing them of the classification, which we understand is according to obviously the services which they had originally been registered to provide. All these letters are supposed to be sent by the end of the week. We have been on a signing expedition, in fact, in the last few days. So you should all be receiving the letters where you will see the class under which you have been classified. The way we have phrased the letters, in fact, is that unless we receive any objection from your end, that will be deemed to be a conclusive class. On the other hand, if, for example, you have been classified as a Class C because originally you had applied to offer all the CSP services under the CSP Act, but in fact, the only service you intend to provide is company incorporation, for example, and you do not have any intention to provide any of the other services, in that case, you can contact us. And you can tell us, look, in reality, we do not want to offer all the services. We are only offering company incorporation, and we do not intend to offer any other services. So we would like to be reclassified. In that case, then we will follow up. Of course, we will request some documentation and some confirmations from our end, and then you will be reclassified accordingly. It's very important to make sure that you are, in fact, offering only the services within that license, because if, for example, you are classified as Class A, but as you know, we have information which we receive in our annual compliance returns, and we realize, for example, that in effect, you are offering, for example, directorship services as well. If then you are classified as a Class A, what would happen would be that would mean that you are offering services outside of your license. So in that case, obviously that would be practically providing certain services without the necessary license. So it's very important to make sure that in the class you fall under covers all the services which you are offering.
It is still not clear what the obligations for an under threshold are. Could you kindly clarify?
So this is a repeated question in every webinar we go, and in every question that we receive. I have to say it's one of the most popular we have. What we want, the message that we want to send out there is that, first of all, as I already indicated earlier, the rule book is principle based. We do not want a tick box approach. We want our license holders to do their own assessment, their own judgment. So when someone asks me this question, I asked someone and I said, like, why do you want to know the specific areas that will be applicable to you? And obviously this person was busy and all that, but we expect at least that our applicants read the whole rule book, and together with the guidance, together with the FAQs, and then make their own judgment. The authority does not have visibility of each and every business model. You can have someone who is an under threshold Class B offering directorships to 2 companies, but then based on jurisdiction or other factors, they are deemed to be high risk. This is the assessment you have to do. And basically, even, for example, the risk management function is applicable to everyone, but having a risk officer is for Class C. It's a mandatory requirement for Class C. But we're not saying that anyone who is Class A, even under threshold, does not read the risk management function section or does not think about risks. I mean, we want everyone to have a look at all the rule book. It is principle based. We are not expecting that especially the smaller outfits, which are low risk, especially, to adopt all the measures that are there, but you need to make the assessment and adopt proportionality to it. However, what I wanted to say is we take note that there is this request, and we will be thinking of reorganizing or issuing further guidance in the near future. However, we're talking about ongoing obligations here. So we wanted to focus our guidance on the authorization process. So in the near future, as I said, we will be looking into that. But it is imperative and important that everyone knows what is in the rule book. I mean, we don't expect you to know each rule, what it says, but at least to have a general idea that is something that is in your interest as well.
Other than difference in share capital and PI, what special treatment will be afforded to under-threshold categories?
Okay. So what did strike me is the word special treatment here. We do not intend to have any special treatments to any CSPs. We are talking about regulating a sector and raising the bar with respect to the supervision across the board. But what we wanted to say is that we want to adopt a proportionality approach to the supervision and to the authorization. So the PII, the share capital, those are, how can I say, the basics. But then with respect to other issues, you know, we want to adopt a proportionality aspect. And this takes us back to the usual that you need to have a look at the principles and adopt the same the measures according to your business model. We will be doing that once we have visibility of the whole sector, once we have all the applications do come in. We intend to do feasibility studies about the supervision and what will happen during provisional authorization and beyond, basically.
Should I wish to stop providing CSP services and client is informed I am no longer offering registered office service, I send a letter to the MBR stating that I am no longer offering a registered office to the clients and want to serve all several relations. Would this be sufficient proof for the MFSA to show that I am no longer providing such services?
So I'm glad this question is being asked in a webinar and not live, because I know it's a contentious issue and possibly I could be in danger for replying to this question. So I'll be answering this in reverse, actually. So as some, for example, licensed CSPs already know, when it comes to registered office service, simply sending a letter to the MBR for the purposes of authorization and for licensing purposes is not deemed enough for the relationship to be deemed terminated. So whilst in fact what I wanted to clarify here, because this is a question which has been raised a number of times as well, in the FIAU updated implementing procedures for CSPs, they did specify that for AML purposes and therefore for ongoing obligations and for ongoing monitoring, where the letter to the MBR has been submitted indicating that the relationship has been terminated and they want to sort of sever ties with the client. In that case, for AML purposes and for ongoing monitoring obligations purposes, yes, that relationship is deemed terminated. However, for authorization purposes, the relationship cannot be deemed to be terminated. Even the MBR itself, in fact, does not remove the registered office, even when this letter is submitted, because unless another registered office is provided as an alternative, they will not register the change. So what we encourage you to do in this case is that if it's a case of a lost contact client, for example, you can contact the MBR and seek their advice on the next steps. However, it cannot be deemed to be a terminated relationship for us to determine that no authorization is required or to accept the surrender of a license, for example, if we take it in reverse. And the reason for this is, and I wanted to explain this, is not because it's simply it's something which we decide on a whim, but because there is an element of reputational risk when the registered office of a service provider is being used. I'm sure all of you will have been familiar with situations and instances where there were, in fact, for example, mentions in the media about certain companies which were mentioned in the media where the registered office of a service provider was being used. And we do know, in fact, that there were some of these cases which were in fact cases where the letter to the MBR had been submitted, but still the registered office was still appearing there, and so there is a reputational risk to that. So we encourage you to take all the necessary steps to try and basically remove your name from being associated with the companies, and we advise you to, in fact, liaise with the MBR on this.
As per the CSP rulebook, where a risk officer is not specifically employed by the CSP, the role should be performed by a senior official of the CSP or a non-executive director. Does this mean that a risk officer cannot be a person that is both a shareholder and executive director of the CSP?
So, the risk officer, as rightly mentioned, needs to be a non-executive director or a senior official of the CSP. But why did we put this requirement? Basically, the role of the risk officer is to have another check and balance with respect to risks and the operations of the company. So having the director, the executive director, the shareholder, having multiple roles, obviously that would impact these checks and balances. Notwithstanding, we understand that in certain outfits, it might make sense to have the same individual. So we want our authorized persons to have a good look at their conflicts of interest, and these principles needs to be adopted across these roles. We are not saying that you just identify conflicts, but you all need to be aware of potential conflicts between the different roles and manage them and have in place systems that actually manage them in a proper way.
If a client's companies are being put in liquidation, do I still need to apply for a CSP license?
So in relation to positions held in companies which are in the solution, no, for those positions, authorization is not required. If the companies are about to be put into the solution, again, the requirement would not apply. However, we would require, obviously, indication that the process has, in fact, been started to actually put the companies in liquidation. So it cannot be simply an intention. We are going to start discussions with the client to possibly put the company in the solution. It needs to be a situation where there have been actually active steps taken to start the dissolution process. But in that case, of course, if that is the case, we will not require the person to apply for authorization, because it is not our intention to license anybody who is not ultimately doing this by way of business and simply servicing a client which is in dissolution.
If I have been PQs in the past under the updated LH portal, will the portal have my personal details saved, or should I be starting the process?
So if you have submitted an online PQ and the new LH portal, you are one of those lucky ones that will not take a lot of time to resubmit the PQ. Why? Because there is the facility, if you have submitted the PQ online, to upload it. It will be populated with the information, and you just need to check or add or remove any details that are not relevant any longer. The requirement to have the PQ submitted again is not a frivolous one, basically, because the authority will do an assessment on the role based on the area and the new role, basically, that you will be taking. So that's why there is the requirement to have a PQ for each official role that needs to be authorized.
Will companies or individuals providing virtual office services that is used as registered office have to apply under Class A license?
So this is a very interesting situation that we are facing at the moment. These virtual offices, we are looking into them, and we intend to issue some form of guidance out there. But what I wanted to say here is that if the agreement between is simply a lease agreement, and you are not holding yourself out to provide a registered office for MBR purposes, so that the company will have an office, then those will be deemed to be administrative. However, as I said, we are still carrying out a feasibility study to see what will be considered as being a registered office or not. But I think over the weekend I came across something that said that you can use the address for the certificate of incumbency. For me, that is basically providing outright registered office, and you're actually advertising it. So you are holding yourself out. So in that case, yes, you need a license in terms of Class A over threshold.
For existing CSPs qualifying as Class C, what qualifies as a small CSP for the purposes of determining independence or otherwise of the risk officer? Can the compliance officer also act as a risk officer?
Okay, so indeed, first of all, these need to be taken on a case-by-case basis. As Alison mentioned earlier as well in some of the questions, we do not have visibility of all the business models. We wish we had a very complete set of 20 perhaps, and we could fit in everything according to those specific 20. But unfortunately, the reality is that there are so many different business models and so many different dynamics within a licensed entity that we need to assess these on a case-by-case basis. However, as for the next question as to whether the compliance officer can also act as the risk officer, the answer is yes.
Can the MLRO and risk officer be the same person?
The answer is simply yes. However, we need to take into account any potential conflicts, the business model of the authorized person, how big or how small it is, but it is allowed, as Petra mentioned, and we've been repeating, it's on a case-by-case basis and depends whether there will be any other conflicting roles.
Once you have provisional authorization, how are you supposed to present yourself to the clients? Can you still present yourself as an authorized CSP class?
So yes, if you have been provisionally authorized, then yes, you have every right to say that you are indeed an authorized person, as ultimately you have complied with the requirements at law and submitted the application with the necessary requirements. So as a reward for being compliant, you get to be provisionally authorized, and you can get to use that as well, obviously, with your clients. Having said that, obviously, there is the caveat in the law which says that, of course, then you will be required to submit any other documentation and information which the authority may require to continue with the full process of the authorization.
As per the CSP rulebook, the person appointed as MLRO of a CSP, that is, a legal person, should be an officer of sufficient seniority and command. Can the MLRO be a person that is both a shareholder and executive director of the CSP?
So, as you are aware, in recent years, there were amendments to the FIAU implementing procedures, and it has been made clear that the role of the MLRO, the person holding the role of the MLRO, should ensure that there is no situation of conflict of interest. So, I cannot give a straightforward answer and say that this is a yes or a no. However, as we would need to look again at the particular setup and the particular position being held. I can give an indication that we have had instances where, for example, it was a sole shareholder or a majority UBO, for example, and a managing director, where clearly, therefore, and possibly the managing director who is also responsible for bringing business into the company. So if there are various elements which could lead to a conflict of interest, it could be the case that we do not accept that person to hold the MLRO office as well. However, as I said, we would need to look at this as well on a case-by-case basis. However, you can take this as an indication, and that has to be your starting point, whether there are any possible conflicts of interest or otherwise.
Where a CSP is a legal person, can its compliance officer be a person that is both a shareholder and executive director of the
So the answer to this is quite similar to the previous question again as well. And for the compliance officer, again, we would, the requirement, the basic premise is that the compliance officer has to be in a position where he is capable of exercising independence of judgment, and basically what we call that there shouldn't be in a licensed entity a situation where the compliance officer is correcting his own homework. So in that case, again, we need to be careful whether the compliance officer, whether in his other roles which he holds, there could be a potential situation which would jeopardize that person's independence of judgment in making the necessary assessments and the compliance work to ensure that the company is in fact acting in compliance with all the applicable legal and regulatory requirements.
What are the exact obligations, financial and professional, for each class of registration? This is an important subject matter, whether to register for the CSP regime.
So I believe I can never stress enough how how it is important that you all have a good read of the rule book, which I will repeat over and over again. It is principle based and it should be read in its entirety. No specific section applies to a specific class or anyone in particular. We need to stress that you need to have a look at the whole rule book, all the guidance note before deciding whether you need authorization or no. It is well, this question is welcome because this person is saying that he or she needs to understand the obligations before deciding whether to apply or no, which is something which is very, very positive, that it is the homework that we expect applicants to do at this stage, but we will not be able to pinpoint to a specific question, principle, or FAQ, because the business model of each applicant is different. So this is the homework that you will be doing. Notwithstanding, we will be happy to guide you. You are more than welcome to send your specific situation to us on our email address, and we will guide you.
Can you have more than one user for the same applicant linked to the same account?
Okay, so the way that the system has been devised is that you need to have one user. So at this stage, we need to have, it is limited to one user. However, what I wanted to say is that the way the application form is devised, it is not necessary. You can actually download it from the MFSA website or the link on the LH portal, save it on your system, complete it in your own good time, and then the user will be able to upload it. So it's quite a simple process that we have created, which should not make it necessary to have more than one user. It is something that we have to live with at the moment from a technological point of view, but I mean, we are trying our best. And as I said, it's a very easy process to follow. In fact, earlier this week, we have issued the guidance on the implementation, and I understand that it could be very basic for some of you, but we wanted to have the simplest of procedure on how to upload, where to find the information, and what needs to be done.
The last two questions for this webinar. I am a new applicant, so if I understand correctly, I would need to apply under the CSP authorization provision and authorization application form, correct?
Well, when you say you're a new applicant, basically we have to distinguish whether you are already providing the services and you were previously exempt. If you were providing CSP services either because you fell under the old de minimis rule or because you were a warrant holder, we have devised a specific application form which can be found on our dedicated webpage, and that is the form that needs to be completed and uploaded to apply. However, when you say new applicant, if you are not providing any CSP activity and you want to start a new entity, or as an individual you want to start providing the CSP activity, then you need to complete what we refer to as the old form. We refer to it as the old form because it is the form that is used for authorization purposes still now. And it is also available on our website, and we have also included links in the implementation plan that we have issued earlier this week, so that it is easier for you to follow.
If one acts as a director and company secretary of the same company, are these two considered as two separate engagements?
So no, in this case, where an individual is holding both a directorship and a company secretary position in the same company, those are deemed to be only one position.
Thank you. I hand over the conclusion now to Emily Benson. Thank you.
Thank you all for listening with such attention to this webinar. I hope that my team have given you a lot of useful information and put some of your concerns at rest. In my concluding remarks, I was just going to cover a couple of points that have come through from some of the questions we've had. One point that I want to make clear to you is that when you apply, you don't need to worry about which class, because we're going to tell you which class you are. So you put your facts down and we'll tell you which class we think you sit in. And then if you think we've misunderstood the facts, then obviously you'll get in contact with us and we'll work through it together. So it's not a case of trying to select a class by reference to what sort of compliance obligations you want. You are going to be what you are because of your business model. Secondly, I think that I know that a lot of people out there are thinking hard and considering whether to apply. And in taking that decision, quite rightly, they're going to look at the exemptions and they're going to look at the by way of business guidance. The exemptions are very specific fact patterns. They are black and white. You either are or you aren't. And so it's not really sensible to look at them very carefully if they just don't apply to you. So coming on to the by way of business guidance, we're going to look at the facts of each situation. And when you're thinking about whether to apply, I would ask you to think of it from our perspective. If you haven't applied and you are clearly carrying on CSP services by way of business, we're going to wonder whether this is because you didn't want us to do the due diligence on you, or we're going to wonder whether it's just a misunderstanding. But the fact is, whether or not it's a misunderstanding, you will have to stop trading until you seek authorization. You will have to tell your clients that you have to stop trading until you seek authorization. If in a very serious case, we find someone trading without authorization, we do have the ability to impose fines under the Act. We won't do this except in egregious and intentional breaches. But I do recommend that you do consider that application is the best route if you want to provide these services by way of business. Once it's done, you can sleep easy at night, and you don't need to worry about any of these nasty consequences. So please, I hope that you will find through this webinar and through all the materials on our website that you will be able to navigate the application process easily. Thank you again.
مش تيهو الكاميرا. Thank you, Emily. That brings us to the end of today's webinar. I would like to once again thank all our speakers and attendees for having participated in this webinar. My final thanks go to the communications and technology teams here at the MFSA who worked behind the scenes to make this webinar event happen. I stress once again the importance to visit our website. All the resources are available. FAQs, acts, regulations, they're all over there. And if need be, you can contact us via email as well. Have a good day and stay safe.